Earlier this week, President Cyril Ramaphosa decided to take the report that found he may have violated the Constitution on review at the Constitutional Court. In light of all of this, calls are growing for Chief Justice Raymond Zondo to recuse himself. Some ANC members, including Tony Yengeni, have accused Zondo of bias on some of his public and private statements in the past. Some experts have also questioned the rationality of taking the report on review at all, saying that such an act seeks to undermine democracy and the Constitution. Joining me to unpack this further is Researcher Fellow at the Public Constitutional and International Law Department at UNISA, Dr. Felix Dube. Dr. Dube, thank you so much for your time and thank you for joining us this morning. I want to start with the review application itself and the merits of the President's case in this instance. I mean, what strength does his application have, given the fact that, as we know, parliamentary processes with regards to the Section 89 panel review process haven't been completed?
Thank you so much, and always a good morning to you and to the viewers. I'm of the view that if we're going to look at the merits of the President's application or its chances of success, we must look at the nature of the report itself. What was it for and what was its mandate? First of all, we should remember that the nature of parliamentary work is political, highly political, and there will always be desires to remove certain people from their position or to impugn their dignity. That's the nature of politics. So when Parliament established this panel, this independent panel, it was meant to ensure that if it was to start an impeachment process, it had a solid ground on which to start that process, so that they do not engage on an impeachment process on frivolous ground. And now this independent panel has decided, he has ruled, not really ruled, but he has expressed an opinion that there is a case to be answered. So now when the President goes to the Constitutional Court, the question that must be answered, in my view, is not whether really is it about him or will he succeed. It is about its implications on the future of parliamentary work regarding these impeachments. So if the court is going to overrule or set aside that panel report, what does it mean in future cases? We might have in future cases where a president has been accused of serious crimes and an impeachment process is about to start, but then the court overrules it. In my view, this is how it could have gone. It should have proceeded from the premise that this report is not a final report. It did not conduct a thorough investigation. It was meant to see if there is a question to be answered or if there are questions to be answered. And it is ruled in the affirmative. So I'm of the view that it will be a bit premature for the court to intervene in this regard. I think they should let the parliamentary process run its way, precisely because the evidence that the panel considered has not been tested thoroughly. Those allegations have not been proven. So I think the court will be a bit putting the cart before the horse if it was to set aside that independent panel report.
Right. So you're making the assertion that this entire move is one that is premature, but I do want to delve deeper into the reasoning that the President puts forward in his application, one being that the panel itself exceeded its powers and mandate, the other being that it misjudged the information that was brought before it. We know that the scope of the panel's work was limited to information brought forward by members of Parliament, information brought forward by the likes of the UDM, ATM and the EFF. What do you say to the grounds of justification for this application that the President is bringing forward, particularly as it ascertains to the powers, mandate, and whether or not the panel misjudged the information at all?
I'm of the view that the panel was not really obligated. Its mandate was not to judge whether the information was true or not true, whether it considered evidence or not. In my view, its mandate was to establish whether the little information or the information that was available to it establishes a situation in which the President might have to explain certain things. That is what they were supposed to do. And they reiterate many times in their report that we have not tested this. We have just looked at this evidence and we are of the view that there are several constitutional and statutory contraventions that need to be answered or explained away. The Parliament didn't have that opportunity to test those allegations. Those allegations will be tested at a later stage. Its mandate was just to establish, is there a case to answer based on the evidence that we have? And I'm of the view that they ruled correctly, that indeed there are certain questions to be answered, and it doesn't mean that the president is guilty or not. No, it just means that there are certain things that need to be explained, things that were not so very clear.
Well, Felix, we know that on Tuesday, parliamentarians are sitting down for a debate on whether or not to adopt the Section 89 panel report. If they vote for that, we know that an ad hoc committee will then be established to test the allegations, as you've asserted. But if Parliament decides against adopting the panel's report, would that be reason enough for political opponents of President Cyril Ramaphosa to then take Parliament to the Constitutional Court, potentially in another case like we saw with the EFF versus the Speaker of Parliament, where political parties feel as though Parliament is failing to hold the President to account?
Yes, I'm of the view that the obligations of Parliament is to maintain a system of checks and balances on the executive, specifically the president, to ensure that they remain within their acts remain within the lawful boundaries. So when they are of the view that the president has not acted properly or has contravened the constitution, they are obligated to investigate, to institute a process and establish the veracity of those allegations. So in the event that the majority of members of Parliament say, you know what, we are not going to adopt this report, we do not feel that the president has got a case to answer, that is within their rights. What will then happen is those who are aggrieved by that parliamentary decision can then go to court and say Parliament has failed to fulfill a constitutional obligation. You recall that one of the constitutional duties of Parliament is to hold the executive and the president himself accountable. So if they fail on that obligation, either by outrightly refusing to undertake that obligation or by just shooing away things, then whoever is aggrieved may go to court and say, you know what, Parliament has failed to fulfill its constitutional obligation. Then the court might then have to look at the evidence before it and the context of the matter and might then direct Parliament to do a specific process. The good thing is we already have the jurisprudence from those Zuma cases, the EFF cases and the UDM cases. We already have the jurisprudence on that. So there is little doubt on what the court could do. The court can order Parliament to undertake its constitutional obligations. But I should warn here that the intervention of the court in itself would not result in greater accountability, because there is always a way to sidestep these things or to avoid them. But the court will just be affirming that in our constitutional democracy, Parliament has got a duty, and if it hasn't fulfilled that duty, then whoever is aggrieved by it can take Parliament to court, and then the court can rule on that Parliament can.
Felix, unfortunately, the line letting us down there at the end as you were giving us your parting shot. But I want to thank you for coming onto the program nonetheless. That was public, constitutional and international law expert from the department at UNISA, Dr. Felix Dube, joining us on the line there.